This presentation will present an overview of social media and the discovery process by Sarah Nelson and Marcy Norton Thomas. Social media is everywhere in our lives, at work, at home, at play, and at school. The prevalence of the medium makes it a potentially prolific source for evidence in many types of cases, whether they be criminal, civil, family law, employment law, or personal injury cases. However, the law has been slow to keep up with some aspects of allowable methods of finding and using social media posts and photographs in court. We'll discuss some of the basic rules and practices of using social media posts in discovery so far. Some of the main points we'll cover include these. What is social media and what constitutes a social media post? What's our duty to preserve social media postings? What are the methods of preserving them? What are the consequences of failing to preserve postings? When, if ever, is social media considered private? How do you determine whether a post is relevant to your case? How do you determine when an access request for social media data should be limited? And can a third party be compelled to provide access to postings? What is social media? Social media is defined as different forms of electronic communication through which users create online communities to share information, ideas, personal messages, photos, and other content. Exactly what constitutes a social media post? Posts on personal accounts like Facebook, Twitter, Instagram, and other internet-based websites all count. Also, fundraising sites like GoFundMe.com, document management sites like Dropbox, and e-rooms, which are internal collaboration applications maintained by companies for document and calendar sharing, discussion boards, and archiving emails. What is our duty to preserve social media postings? If a party can reasonably foresee that data in a social media platform could be relevant to a case being litigated, it must be preserved. A litigation hold notice should be sent to the opposing party. That triggers an obligation to preserve such posts. The duty to preserve data on social media platforms is the same as the duty to preserve electronically stored information on other platforms, such as email. What are the methods of preserving social media? Social media sites offer the ability to preserve your postings. For example, Facebook has Download Your Info. That allows you to preserve posts, messages, photos, IP addresses, and other data. Twitter offers a limited archive option for preservation of tweets. Other non-public information, such as IP addresses, is available by request. Companies can use third-party vendors to preserve social media data. The vendors include X1 Social Discovery and Cloud Preservation, among others. Clients should be instructed to not delete postings. This could be perceived as destroying evidence. What are the consequences of failing to preserve? The consequences of failing to preserve social media evidence can be significant. The court could find the offending party negligent but not impose sanctions, or counsel or the client could be subjected to sanctions. Also, a court could determine a party committed spoliation. In one case, the defendant was ordered to restore a photo until the plaintiff had time to review it. When is a social media post private? This can be tricky. Social media's main purpose is to share information with others, and private is not the same as not public. Sharing content with others tends to erode your expectation of privacy. In the case Richards v. Hertz Corp., the discovery of a public Facebook photo, which helped the defendant's case, resulted in a successful appeal for access to private photos and posts on the plaintiff's Facebook page. The court found the public photo indicated that relevant private postings could also exist. One judge put it this way: the courts have generally concluded that there is a usual communication rule that if you don't want anyone invading your privacy, you shouldn't tell 1,000 of your closest friends and expect that it's still private. Determining relevancy of a post. The standard for discoverability of social media postings is generally the same as for other documents: whether the request could reasonably lead to the discovery of information relevant to the claim. How have courts dealt with the issue of relevancy? There are several ways. One is in-camera inspection. That's when a judge reviews the data and only grants the requesting party access to parts of the data that the court deems relevant. Also, attorney's eyes only. That's when counsel is allowed to review potentially relevant postings to determine which are relevant. The data used depends on further court rulings. Or you could use a forensic expert to serve as a special master to review the content. You can also assign an impartial agency to determine privilege of any content turned over as a result of a discovery request. Discovery requests and the limitations. In most cases where social media discovery requests fail, it's because courts rule that a legal team is on a fishing expedition. Too broad a request is overly burdensome and meant to harass the other party. The court is more likely to comply with a more manageable request. Discovery requests must be calculated to lead to relevant evidence, so so-called fishing expeditions, where relevant evidence might be incidentally caught in an overbroad discovery request drift net, are generally not permitted. Can a third party be compelled to provide access to social media content? According to the Stored Communications Act, online service providers have a limited ability to disclose information about their users or subscribers. Disclosure with the user's consent is allowed, but the Act does not address whether a provider can be compelled by a subpoena to turn over subscriber data. However, courts have ruled the Act does not override the service provider's obligation to produce relevant electronically stored information. So, a court can compel Facebook, Twitter, or other sites to authorize the release of social media content under a properly issued subpoena. In conclusion, there are no set guidelines when it comes to social media and the discovery process. Originally, courts seemed to rely on the motto that more is better when producing information for litigation. But as they've become more familiar with social media, they err on the side of caution. Seeing how prevalent social media is in our daily lives, we imagine there will be continuous changes to the process as courts attempt to better define allowable methods of finding and using social media in the courts.